Hi, good morning. This is Rajeshkumar. Today, we are going to analyze one problem question on mistake. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer. Let's move on to the problem question. Amrita want to sell some goods to raise money. Advise her in the following circumstances. Amrita offered to sell her bicycle to Brian for £500. Amrita intended to offer for sale the bike she used to commute to work. Brian understood her to be selling a more valuable race bike, which she also owns. Amrita was not aware that Brian had misunderstood her offer. Circumstances B, the same scenario as A, except that Amrita was aware that Brian had misunderstood her offer. Amrita only owns one bicycle, which she agrees to sell to Chole for £200. Unknown to Amrita and Chole, at the time they agreed the sale, Amrita's garage, where she kept the bicycle, had burned down, and the bike is destroyed. Circumstance 4, Amrita agreed to sell her only bicycle to Devi for £300, and both Amrita and Devi think the bike is made by Kestrel Cycles, a respectable bike maker, when it is in fact a cheap copy. Let's analyze each circumstances. The first one, the Amrita offers to sell her bicycle to Brian for £500 with a misunderstanding regarding which bicycle is being sold. When parties enters into a contract under mistake believes the law may excuse performance under certain circumstances. In contract law, a mistake is a complex area requiring a precise categorization of different types, namely common, unilateral, and mutual mistakes. This scenario addresses a unilateral mistake in which one party, a brain, is mistaken about the identity on the subject matter. Here, Amrita intent to sell the commute bike differs from Brian's assumption of the race bike, which Amrita unaware of Brian's interpretation. In other words, in this case, the mistake at issue is a unilateral mistake as to the subject matter, where one party, Brian, misinterprets the subject matter of the contract, while the other party, Amrita, is unaware of of this misunderstanding. Under Smith versus Hughes in 1871, the court held that if one party makes an offer without realizing the other misunderstanding, the contract may remain valid unless the mistake goes to the contract terms or identity. Here, Brian's understanding does not alter the agreed term, a bicycle of £500, as it was an error regarding the subject value. Hence, this misunderstanding alone is unlikely to void the contract. In Raffle case in 1864, where the mutual mistake about the ship identity nullified the contract, it was held that the mistake must go to the fundamental fact for the contract to be void. However, a brain's error here pertains to the quality, not the identity of the goods. Consequently, a court would likely uphold the contract, leaving Amrita obligated to sell her commuter bicycle. In other words, the case of Smith versus Hertz establishes that a contract is binding if there is an agreement on essential terms. If even if one party holds a mistake assumption, as long as the other party is unaware of it, thus Brian's misunderstanding alone does not void the contract unless the mistaken belief is essential and known to both the parties. Hence, Amrita should proceed with the sale if she is willing to sell her commuter bike to Brian. She is not required to provide the race bike unless both parties explicitly discuss it. Since Amrita was unaware of the Brian's mistake, the contract could still be valid if there was a meeting of minds on selling a bike for £500. However, if the court finds that the Brains believe in buying the race bike fundamentally changes the contract's nature, they may decide otherwise. Let's move on to the circumstances two. The same situation of A, but Amrita is aware that Brian misunderstood her offer. This case addresses a unilateral mistake known to the other party. In this case, Amrita is aware of Brian's interpretation and does not correct it, making this a situation where contract might be voidable. In other words, here Amrita is aware of Brian's misunderstanding but chooses not to clarify it. This introduced the concept of unilateral mistake with knowledge. Hattock versus Collin and Shields in 1939 case established that where one party exploits other error, the contract may be voidable. If Amrita's knowledge of the Brian mistake indicates she intended to deceive or take advantage, this could affect enforceability. In such circumstances, the court may treat the agreement as voidable, especially if Amrita's awareness of Brain's mistake belief could be deemed a form of misrepresentation by silence. Hence, the court might release a Brain from the contract if it determines that Amrita intentionally allowed Brain's misunderstanding. In Hartog versus Colin and Shield case illustrate that if one party knowingly allows the other to misinterpret the contract terms, it may invalidate the contract. Here, since Amrita is aware of the understanding, Brian could argue that the agreement was void due to misrepresentation or a known unilateral mistake. Hence, Amrita should clarify the nature of the bike to avoid the risk of the contract being voided due to misrepresentation or unilateral mistake with knowledge. In other words, given that Amrita is aware of Brian's mistake, the contract could be voidable at Brian's options. As a misinterpretations affects the identity of the bicycle he thought he was purchasing. Scenario 3. Amrita sell her only bicycle to Chole, but the bicycle is destroyed in a fire before the sale was finalized. Here, the common mistake relates to non-existence of the subject matter at the time of contract formation. This situation involved a common mistake regarding the existence of the subject matter. Both parties were unaware that the bicycle, the contractual subject, has been destroyed. Section 6 of the Sales of the Good Act 1979 provided that if the goods perish without the seller's knowledge at the time of the contract is void. This rule, as confirmed in Courtier versus Hasty case in 1856, releases both the parties from obligation when a common mistake pertains to the existence of goods. In other words, Section 6 of the Sales of Goods Act 1979 applies here, stating that if the goods are perished at the time of the sale, the contract is void. This is reflected in quoted case where the goods no longer exist at the time of the contract, making the contract void due to impassibility. Hence, Amrita is not required to perform the contract as it void under Section 6 of the Sales of Goods Act 1979 due to the non-existence of the bicycle at the time of the agreement. Hence, neither party knew the bike was destroyed, the contract would be void due to the doctrine of res extincta. The subject matter did not exist at the time of agreement, nullifying the contract. Let's move on to the last scenario. Amrita agreed to sell her bicycle to Devi, but both parties mistakenly believe it was made by a Chrysler Cycles. This situation involves a common mistake regarding the quality of the bicycle, not its existence. Here, both parties make a common mistake about the quality. rather than the existence of the item. The law, particularly in Bell versus Lever Bros Limited in 1932, generally does not void contracts for quality based mistakes unless they affect the item identity. The bike's brand does not alter its identity as a bicycle. Therefore, this mistake does not make the contract void. In other words, Bell versus Lever Bros addresses the mistakes concerning the quality of goods and establishing that a mistake about the quality typically does not void a contract unless the mistake makes the subject matter fundamentally different. However, Great Fish Shipping narrowed the application of this principle, suggesting that quality mistakes would rarely void a contract unless they fundamentally alter the agreed terms. Hence, Amrita and Devi are bound to the contract terms as the mistake does not impact the bicycle identity, but rather it perceives the quality. Hence, since the bike manufacturer was not explicitly warranted by Amrita, the mistake regarding the quality may not be sufficient to void the contract. Davis' disappointment in the quality is likely not the ground to void the contract under current doctrines of mistake, as it does not fundamentally change the contract's nature. Let's conclude. The contract may be valid in the first category, in the first scenario, because the mistake is unilateral and Amrita was not aware of the brain's misunderstanding. In scenario two, the contract is likely void due to Amrita's knowledge of the mistake. In scenario three, the contract is void under Section 6 of Sales of Goods Act 1979 because the subject matter had perished. The last scenario, the contract is likely valid despite the mistaken beliefs about the bicycle manufacturer, as it is the mistake of quality which does not usually void a contract. Thank you.